Hello, I'm Cody Wright, and I'll be speaking on the early formation of the judiciary system in America. If we do not maintain justice, justice will not maintain us. Francis Bacon, an English philosopher. Equal justice under law. These words were sculpted on the Supreme Court building in 1732 and are the ultimate responsibility of the Supreme Court. Equal justice under law stands for the fairness of trial and for lawbreakers to meet their appropriate consequences for their actions. It all started in Article 30, Section 1 of the U.S. Constitution, where it states, "The judicial powers of the United States shall be vested in one Supreme Court, in such inferior courts as the Congress may from time to time ordain and establish." These words written in the Constitution are the early formation and base of the federal court and Supreme Court in America. The definition of the judiciary branch is a branch of government that is endowed with the authority to interpret and apply law, adjudicate legal disputes, and otherwise administer justice. Judges and justices must protect and preserve constitutional government by following the rules laid out for them in the U.S. Constitution. It all started with three main events. First, the Judiciary Act of 1789, formally called an act to establish the judicial courts in the United States. This act was signed into law by President George Washington on September 24th, 1789. This act established the structure and jurisdiction of the federal court system and birthed the position of the Attorney General. Although amended throughout many years by Congress, the basic outline for the federal court system remains largely intact today. The second event, also in 1789, is when Congress established circuit courts. At the time, justices were assigned to 1 of 3 circuit courts. Judges and justices would go to and from the circuit courts they oversaw and the Supreme Court, something called circuit riding. In 1911, circuit riding was removed because it was unfair and caused too many problems. The third event, the very next year, the Crime Act of 1790, was the first incomplete list Congress put out naming 23 federal crimes and offenses. This act was a move away from the colonial era tendency to make the death penalty the punishment for any serious crime. In the groundbreaking case, Madison versus Marbury, the Chief Justice at the time, John Marshall, who was the 4th Chief Justice, declared the Supreme Court's responsibility to overturn unconstitutional legislation was a necessary consequence of its duty to uphold the Constitution. This case was very big and important for the early Supreme Court and is still largely depended on today. In conclusion, without the federal court system, America would be a place of contradictions, inconsistency, and injustices. The federal court system has been clearly a success by maintaining the oldest constitution still in use. Equal justice under law is clearly and evidently what makes the federal court system in America so great. Thank you.